All right, so there's been a lot of changes in recent months and recent weeks in the UAE, and so I want to set expectations about today's session. This session is being recorded. It will be made available on the CIPD Middle East YouTube channel and shared with all of those who registered today. Now, with that being said, those who are with us live right now will have the benefit of being able to engage in discussions in the chat, and we'll be picking up some questions. This free 1-hour session is designed to help bring some clarity over the recent changes, legislative changes in the UAE. We'll cover the major updates and their applications, but we will not be going into all the details and the hows of these updates, neither of the broader entire UAE labor law. For this, we have a UAE Labour Law course, which is a 2-day course designed in collaboration with and delivered with Clyde Co. And the reason why we'll not go into all these details today is twofold. The first is that we have just 1 hour to cover a lot today. And the second is that, like Sara explained to me, the new law introduces a number of unexpected changes. The rationale for some of these changes is not always clear, and it is difficult to see how some of the provisions will operate in practice. That's because most of the detail in the new law has been left to the forthcoming executive regulations that will be issued later. It's hoped that these will come out soon and that they will bring out clarities in areas that are still grey. But nonetheless, there are still a number of significant issues that we can cover today and answers that we can give you. Please bear in mind that we will be covering all of these from an employer point of view. So we'll not really go into detail as to how this affects you as employees, but we're really trying to address you HR professionals. If you're looking for regulations or updates regarding Saudi Arabia, please stay tuned. We have scheduled a webinar for January next year for Saudi Arabia specifically, and that whole new headquarters law and how this will affect us and who this will affect. So if there is one thing that we have learned when living and working in the region is that when changes come, they come fast. Just over 18 months ago, I was sitting here with Sara Khoja, partner at Clyde Co, who's here with me today again, over what was our very first CIPD Middle East webinar to try and bring clarity over the temporary measures and the legislative changes that had been made by the UAE during COVID. At that time, the law, which hadn't been updated in years, included no provision whatsoever regarding flexible working. Paternity law was still only covered under the DIFC law. Working from anywhere was a very unknown concept, except for some startups and progressive employers. And there was nothing limiting working hours, and many other areas are now covered. Since now, quite a lot has changed in the way in which we work and live, and the law is catching up, which is great news. My name is Charlotte Chedeville. I'm the Regional Head of Operations for CIPD in the Middle East. I'm delighted to be your host today. During this session, I will be asking Sara Khoja, my guest, who is a partner at Clyde Co for the Middle East, many of the questions covering the most important updates that we've heard. I will also try and pick your questions in the chat. If they relate directly to the area which we're talking about, we'll address them then and there. If they relate to questions that we will cover later on in the session, please bear with us and we'll pick them at the end. So Sara, thank you so much for joining us and being my guest once again today and helping us all get clarity over this. Can you give us a summary of what the main changes have been and perhaps what are the highlights for you?
Okay, wow. So like you said, there have been many changes. And I'll just try to pick out, I guess, the most significant and the highlights. So going through it kind of a little bit in order of the way they appear in the labour law. Article 4 now has a very robust statement about prohibiting discrimination on the grounds of someone being a member of a protected class, so on the basis of gender, sex, religion, age, a number of instances. And that's quite new in terms of how wide it is and how sort of strong the language is. So that's one change. And then other changes include recognition for different work models. So I think some of what the new law is doing is that it's recognizing what's actually happened in the market, and it's consolidating and updating the labor law so that it is it's more akin to the way that we work now, especially after COVID. So the law now recognizes full-time work, part-time work, flexible work, and temporary work. And whilst it contains a definition of each of those four things, it then says that the implementing regulations will give us more detail about what these mean in practice, how you would operate it as an employer, whether the contract terms are different because of these different types of working, and whether the benefits are also different. So like you said, the executive regulations or the implementing regulations are really going to have a lot of key detail. So we just have to wait and see. Some of the other changes are with contracts, which I think many of our attendees will be grappling with at the moment, because talking to employers, this is one of the big things that has come out in the new labour law, and one that they are all thinking about how they're going to implement. So under the existing law, we have fixed term contracts and unlimited term contracts. Under the new labour law, we only have fixed term contracts, but they are fixed term contracts which can be terminated on notice. So there's a lot of flexibility there. There's a lot of, I think, pro-employer provisions there. Now, one of the hard, I suppose, operationally, one of the most difficult things with this new law is that it says very clearly, so the law is super clear on this, that all employees have to be on fixed term contracts, and existing employees have to be moved to fixed term contracts if they're on unlimited term contracts, or I think the word that the labour law uses is indefinite term contracts. So these people have to be moved over, and employers have a year from the 2nd of February, so until February 2023, to do that. Why has the Ministry of HR done this? I have to say I don't know. It is a very pro-employer measure in that the reality is, when you are, your commitment as an employer is to employ somebody for the fixed term. When the fixed term ends, you your obligation ends, you pay them their final entitlements, and then they could very easily exit the business. So it is very employer friendly in that sense. And then final point before we kind of unpack it with you and discuss it a bit more, end of service gratuity, which again is one of the big highlights and which a lot of employers are asking about. So we still have end of service gratuity. We have the same formula, conditional on a year's service, 21 days for each year for the first 5 years, goes up to 30 days after that, and then 2 years cap on the overall benefit. So somebody roughly has to work for about 24 years before they get to the cap of 2 years. Now, the big changes are there is no adjustment for resignation. So at the moment, we have in the labour law this kind of staggered basis of reducing gratuity depending on how long somebody has been with the company when they resign. And 5 years is kind of the golden rule or the golden benchmark. If they have less than 5 years, then it's reduced. If it's more, then it's not. All of that has gone. So now it doesn't matter whether the employee resigns, doesn't matter whether the employer dismisses, gratuity is always going to be the same. So that's a big change. And then the other big change is that gratuity is always payable, even if you dismiss for gross misconduct. Now, the final change, which I think what I'm saying to a lot of employers is, let's wait and see. I don't think the law is clear. We have a reference in the gratuity section now in the new law saying 21 working days, 30 working days. So now when you're looking at that as an employer, we all know at the moment it's done on calendar days. So, you either take the monthly salary or the yearly salary and divide by 365 or 30 days. And now looking at on the face of it, if we're going to start doing that on working days, then end of service gratuity has gone up a lot. The value of end of service gratuity is going up by like just over 30%. So understandably, a lot of employers are a little bit alarmed that, you know, their accrual is going to have to go up significantly. Now, at the moment, what I'm saying is that it's not clear. Yes, there is this reference to work days, but the law doesn't make clear what it means by work days. Article 1 contains all the definitions that apply in the labour law. And for workday, it says that the implementing regulations will specify what a workday means. And I think the reason why it's been done like that is because we have, as I was saying earlier, now 4 different models: full-time, part-time, flexible, and temporary. And so what I think the implementing regulations are going to do is that they're going to tell us how to calculate work days for each one of those models. And I'd anticipate that the gratuity is still going to be on calendar days. But I might be wrong. I might be very wrong, but I would be surprised if the government has uplifted gratuity by 30% for everybody. So we'll just have to wait and see. But at the moment, I think let's as employers, let's wait and see.
Thank you. So like you said, quite a lot to unpack, but already some clarity over the regulations that we've heard. Shall we start with the changing contracts and unpack this a little bit more, because I know that's a big one for employers. So you said employers have 1 year from the moment the law comes into effect in order to operate that change and move all existing employees onto limited to fixed term contracts. And of course, any new employee will have to be moved on to that. What does this mean operationally? And are there any things that employers should consider when making that change?
So there's 2 points in the new law. It says it gives the 1 year to do the change. It then gives a mechanism or a process for making that change. There's a provision there saying that you can terminate the existing contracts on notice, and the notice to terminate so that you can move people over is linked to their length of service, and it can go from 30 days up to 90 days. And so as an employer, you have the choice of, you know, when to serve that notice and move people over. Now, I think from an operational perspective, obviously having to move everybody over, depending on the size of your business and what your headcount is going to be a big operation. And going forward, you kind of have to start thinking about it in the practicalities and, you know, what does it mean? And I think, you know, one thing you do not want to do as an employer is put everybody on the same start date, because, you know, you don't want to terminate everybody now and move everybody over at the same time. You want to do it on a staggered basis, not least because we are going to start moving people over to fixed term contracts. For example, and this is just a practical point when you apply the law, if, for example, you have your team, I don't know, of marketing people, let's give that example, and you have 10 people in that team, and you decide that you are going to move all of them over at the same time. So you terminate them all at the same time. You give them all new contracts at the same time. You give them all, by example, you give them all fixed term contracts of 2 years, because the fixed term can be anything up to 3 years. So they could be less than 3 years. Let's say you give them 2 years, or even you give them the full 3 years. If the way that you've timed it all means that in 3 years, all of their contracts end, potentially you might find a situation where they all exit the business at the same time, which is not what you want as an employer. You know, you don't want to suddenly lose everybody because all their contracts ended and they decided to leave. So I think on a practical point, the year has been given so that you can stagger when you do it, how you do it, and whether you want to do it in batches.
Yeah, absolutely. And I know we need a panel discussion to even unpack the consequences of this for employer and for the economy, but one can already foresee that for HR, both from an employee point of view and from an employer point of view, this changes quite a bit the dynamic as well. It can impact psychological safety, how you're deciding to invest, or I don't know, even economically purchase housing, or how safe you feel in being here on the long term. And from an employee point of view as well, what are you offering in order to increase your employee value proposition? If we are going to be in an economy where talent flows more, perhaps a model which is more akin to Australia, where it's very well known, they have this work and holiday type of visas where people move a lot across jobs with short-term contracts. What do you think of these kind of macro implications, and where do you see employers could do something, so to say, beyond the above and or offer things above and beyond in order to keep people safe, but all psychologically safe, but also maintain their employer brand?
Yeah, I mean, a lot of employers are saying to me, "Do you know, this is going to be very unsettling for our employees because they have the sense that if they're on an indefinite contract, it's indefinite. So, you know, they feel a bit more secure. Now, if I move them over and I say, well, you're on fixed term contracts, this makes them feel that there is, you know, it's finite in time. It's not like I could hold this job for the next 20 years or whatever. And I suppose to make employers feel a little bit better, you could you could give them, for example, the maximum 3 years. You can, when you put the contracts in place, say that the contract automatically renews unless notice of non-renewal is given. And again, operationally, that's useful because it means that you're not every year having to do a new contract, or every 2 or every 3. It just rolls over automatically unless notice of non-renewal is given. And that can be given by the employee as well. It's not just the employer. So those two things could make people feel a little bit more secure. The other thing, I guess, is if you put in place some of your benefits, which basically are geared to longer service. And I think a lot of employers already have this, and maybe with retention becoming more of an issue, there's more benefits and payouts being linked to service. So again, that just gives a message that, you know, we don't operate a system where we sort of churn through people, but we actually want people to stay. So, you know, we are building in comp and ben to take into account that, you know, you are going to be here for the next 3, 5, 10 years.
Yeah, long-term incentives might be more the talk of the town now, and see how you can retain people. A lot of practical questions, so I'll just pick them up now. So now you can have a contract which is up to 3 years, and anything less than that. Will this match the visa duration? Will you be able to issue a visa also for just 1 or just 2 or just 3 years?
That we will have to see, but I think that it makes sense, right? If the labor law is providing for this, I think it does mean, hopefully, that we're going to have more visa options come out, both from the Ministry of HR and in the free zones. I mean, obviously, all of our attendees know that in the free zones you get 3-year residency visas, and at the Ministry of HR you get 2. Hopefully, given that the labour law now has this reference to 3, we'll see the Ministry of HR going back to issuing 3-year visas. Yeah, let's wait and see, but it would make sense that more visa options are introduced now.
Yeah. Another question is, when we are so when employers are going to make the change from the current contracts into the fixed term contracts, would they have to then pay out all the end of service benefits as well before
They
signing
don't
the contract?
Yeah, no, they don't have to, because the employment is continuous, so they can just roll it through. Now, there is this provision about termination. It's not very clear. So again, let's wait to see what the implementing regulations say. But there is this provision that refers to the current law and says that if you were to pay out gratuity, you can do it under the current law. Now, quite what that means is unclear. Let's see what the implementing regulations say. Because if you as an employer are going to terminate, then gratuity would be payable in full. You know, we're not going to get any reduction. And it is for the benefit of employees to roll over. So my advice at the moment, based on the new labor law, is that you could roll it through, subject to anything else that comes out in the regulations.
Is terminating the existing contract the only option for this transition? Like, do you need to terminate the existing contract in order to start a new one?
Technically, well, technically, yes. Technically, you do have to terminate this one and you start a new one. And that's certainly the kind of process that the labour law envisages. I suppose what you could do is you could, on a practical basis, especially for the kind of your company contracts, you could have employees sign addendums that just say your terms and conditions are the same, except that your contract will now be fixed term and say, specify the term. Although I would say the Ministry of HR definitely seems to expect that new employment contracts will be registered. So if anyone's got unlimited term contracts registered with it or with the free zones, they're going to have to put them as fixed term. So that will be paperwork that has to be filed with the authorities.
Yes, because it's a different type of contract altogether. It's not just amending a clause or amending a thing. So it's really having to complete that one and then start a new one, which is probably why you were saying it's helpful that you're giving employers a year, even though considering the size of employers and the time that paperwork takes, one can argue that a year isn't that much at the end of the day. I forgot to ask that question, but for the benefit of clarity for everybody attending today, can you just clarify for us, all these updates today, do they apply to every organization across the UAE, free zones, DIFC, and the rest? Are there changes?
So they apply to everybody across the 7 Emirates and all the free zones, but they do not apply in the DIFC or the ADGM.
And DIFC and ADGM have separate updates
Yes.
to their previous. Yes.
Yeah.
Excellent. All right, so there are so many questions to the implications of these new contracts for gratuity. And I know we've already talked about it, but I feel like that would almost be, we could almost have a panel discussion with comp and ben experts and HR to discuss incentivizing long-term, but also retaining your current talent. I see quite a few people concerned over the fact that with a new contract, you might lose some people, or, how would people who've accrued, say, 10, 15 years of experience and gratuity accept to be moving on to these new contracts? My initial understanding, based on our previous conversations, is that you can always offer more than what the law provides, right? You can always choose to go, and I think that's just really important to consider. That's the minimum that the law states, right?
Yes. Yeah, for definite.
All right, so we may go back to this fixed term contract afterwards. Is there any question that is still unclear for anybody attending right now? I think the main one really, and that's one, I know you don't have a crystal ball, but when are these clarifications and executive regulations expected to come out?
Well, the new law comes into force on the 2nd of February. So I would hope before or on the 2nd of February. I'm not sure, but hopefully before or on. I think that, it's quite common in the UAE, right, for laws to be published or a measure to be introduced, and then for a period of time the government sees, how the market is reacting. They kind of gather feedback. So I'm sure, the Ministry of HR has a draft prepared and has a document prepared, but maybe what they're doing is they're using this time to hear the feedback on the labour law, on the new labour law, and the questions people have, so that they can take these into account in the implementing regulations. But I would very much hope they get published on the 2nd of February, or before. Yeah, we'll see.
Excellent. So to answer to you, Charmaine, who's still a bit unclear on the term of the fixed term contract, can we do 1, 2, and 3-year contracts? Yes, the law says that you can do fixed term contracts up to 3 years and anything under that.
Yes.
Will the previous contracts have to be terminated in order for the new ones to convert to a fixed term contract? Sara, you've said yes, that paperwork needs to be filed because it will be a different type of contract. So you do technically need to terminate the current employment and have your employee sign a new contract that you need to file, right?
Yes.
And at that time, is there an obligation when filing that new contract and terminating the previous one to pay out the previously accumulated gratuity for employees?
No, there isn't. So because their employment is continuing, their employment hasn't ended, so it continues. You can roll it
so
over.
It continues. And then you have the new provision for how gratuity will be calculated in the forthcoming 3 years. plus whatever was previously accumulated.
Yes.
Don't you expect that employees might feel a little unsettled about signing a new contract without having paid out, effectively them having been terminated? Because we know that employees, especially in this country, rarely know their rights and feel like very often the law is protecting employers rather than employees, which it is the case in many, many ways. Don't you feel it could be unsettling to terminate a contract and accept that not being paid out by termination and sign the new one?
Well,
Am
the
I
new
protected
contract,
by the law? As in, am I protected
yeah.
if the employer doesn't pay what I've accumulated until now, when I do terminate my first-time contract, for example, whenever I leave the
Yeah,
company?
yeah. I mean, the answer is yes, because the employer wouldn't have paid you. So, it's not like they can defend a claim by saying we paid. They wouldn't be able to pay to say that. And then the new contract can recognize your previous employment. So as long as you as an individual have a piece of paper that says, I might change my contract in 22, but actually I was, employed from 2004. And as long as I have a piece of paper that says your employment started in 2004, then you are protected.
Perfect. And to answer questions, because there was a lot of confusion around this, visas don't necessarily have to align with the fixed-term contracts, right? So
That's
when,
correct. Yeah.
so for example, let's say my visa is valid for another 3 years. This year, I'm going to get a new contract. I can still run on the same visa because similarly to the point we just explained, I am still employed by the same employer, correct?
Yes. Yeah.
Perfect. All right. I know there's still lots of questions around gratuity, but I'd like to move forth a little bit and go back to that if we have the time and there are so many questions. The other, I think, big question that we had was around, I mean, if there is anything further that you'd like to explain about these new other contracts. I've been covering a lot the fixed term contracts, but you've talked about the fact that today the law covers flexible working for several employers. Can you tell us a little bit more about that?
Yeah. So we now have three more work models. The old labor law was basically very much traditional. It assumed that everybody worked full time and for one employer. But now we have part-time work, flexible work, and temporary work. And so, that's a really big change. And I think we'll see more recognition for how you work for two employers or more, how you work flexibly, and maybe even, working by the hour, and for the hours to change, at different times of the year or, even per week and so on. And then we see that being recognized in the new law because, for example, annual leave. Now there's a clear statement that if someone works part-time, they their annual leave entitlement is prorated according to how much they actually do work. So at the moment we had a little bit of a strange situation where somebody might be working 3 days a week, but because the law didn't provide for adjustment, they were still entitled to the same leave as everybody else, which kind of didn't make sense. But that has changed in the new law. So now with the flexible working, especially, and with the temporary work, we're going to have to wait to see what the implementing regulations say about how, for example, we calculate end of service gratuity for those people, what kind of benefits they're entitled to, because it might be that they will be entitled to sort of less benefits. Because if we look at Saudi, for example, those kind of work patterns have been recognized for quite a long time, but provided that the employer gets the contract right and puts certain provisions in it, then sometimes they are excluded from parts of the labor law. So it might be that the UAE adopts the same kind of model.
You've mentioned leave. I've seen a lot of questions around that as well. So we've seen a mention of study leave. There has been updates to parental leave. Can you let us know a little bit about that and what we know in terms of the minimum that is now required by the law, and if there is anything that was not covered at all previously that now exists?
Yes, so leave is actually definitely a place where there's been a lot of change. So maternity leave now is not dependent on length of service for it to be paid. So any pregnant employee would get the same length of service regardless of whether she's been there for a full year or not. And it's gone up, so it's 45 days, which is it has always been. And then in addition to that, there's another 15 days, which is half pay. So it's a little bit better. And then there is also the right to have time off if the child is ill, uh, if she's ill due to the pregnancy or the childbirth, if the child is born disabled, or if the child is ill. So there's an additional month off for those kind of circumstances. So there's been a bit of change there, and then there's a whole, well, there's new types of leave in terms of bereavement leave. So bereavement leave is now recognized in the law, and it's either 3 to 5 days, depending on the relationship of the person who's died. And the study leave. It's called study leave, but it's actually days off to take exams. And that's only for if you're registered at an educational institution in the UAE. So if you're doing a distance learning course with a institute outside of the UAE, the law doesn't apply to you. And we have parental leave, which of course was announced before, so it was in a ministerial resolution. It is now in the labour law, the 5 working days for a man or a woman. So it could be either. It's not, it has in the past often been described as paternity, but actually it's parental leave because it can apply to either the father or the mother. And then there is a mention of there's a mention of unpaid leave, but it's only a mention in that it says that employer and employee could agree unpaid leave, but it doesn't make it something that the employee has the right to ask for.
Yes, because we saw a few mentions of unpaid leave during the pandemic when there was these 5 steps that employers had to take before deciding to let go of an employee. And there was the option of asking them to take unpaid leave. That was never quite previously there. So now, what are you saying? There is a right, it's not, there is a right now for employees to take unpaid leave. Is this regulated? Is there a maximum amount or?
No. So the law just says that the employee and employer can agree periods of unpaid leave. And
Okay.
unpaid leave, in the same way as at the moment, unpaid leave would not be taken into account for end of service gratuity calculation. So the period of service.
Charmaine is asking 1 day off per week in notice period to look for work. What is this?
Yes. So now when you serve notice on an employee to terminate the contract, which can be between 30 and 90 days, during the notice period, they have the right to take time off to find another job.
Okay. And again, now this is about the new contracts where the notice period can be 30 to 90 days. What about very senior roles where we've traditionally had perhaps 6 months of notice because you needed that time to transition?
Yeah, I mean, this is a big change. So, I mean, since 2017, the Ministry of HR has refused to register a contract which had which had notice higher than 90 days. So they've been applying that rule in practice. But because the labor law hadn't been amended, it was still law under federal law that you could have a higher notice period if you wanted to. And now that is not the case because the federal law has been amended. So anybody who has 6 months notice in their contract, it's in breach of the law, so it can't be applied.
Okay, that's
It's
interesting.
an
So
odd one, and I think a lot of, for a lot of companies with senior people, directors usually have 6 months. Sometimes they even have 12 months, which is, for a CEO, but it's pretty unusual. But again, it's one of those where the law is super clear now. 90 days is just the maximum.
is there a way to have is there still an option for the employer and the employee to come to an agreement? And would that still be a breach?
It would be a breach, and the agreement would be void because the courts won't enforce it because it's not compliant with federal law.
Okay, a lot of questions around terminating contracts and not the gratuity part, but resignation and all that. So if the employee with a new fixed term contracts, so if an employee resigned during the fixed term contract, does the employee need to compensate the employer? Is there anything that, which I think is no, but still, and mostly an interesting question that we are getting is around non-compete. So if we are moving to a more fluid type world, when one could imagine that people work shorter periods of time at more employers across the time of their careers, has there been any amendment to the previous non-compete clauses or laws?
There's a little bit more detail now in the labor law, in the new labor law, about non-compete clauses, but it's still the old rule of they have to be reasonable, they have to be reference to geography, time, and scope. There is now this reference of 2 years in the new federal labor law that that a non-compete could be for up to 2 years. Now, I still think 2 years is an incredibly long time, and I find it hard to believe that a labor court will actually enforce that, unless you've got somebody who's incredibly senior, CEO level maybe, where they could think that that was reasonable, but. Yeah, I think 2 years is in the law now, but I would really, to any employer, I would be saying you'd have to be very, very cautious. And I personally just think it's too long. The labor courts don't like non-compete clauses anyway. And I think if one was for 2 years, they would struggle to agree that it was justifiable. So that's one thing that has changed, this reference to 2 years, these things being able to be up to 2 years. There is a reference now that if the employer breaches the contract, so for example, if the employer doesn't pay gratuity, doesn't pay final entitlements, then the post-termination restriction, the non-compete, for example, will be void. So the employer won't be able to enforce it. So if the employer breaches, they can't rely on the contract. So I think that's fair. That's a provision. And actually, there was a very similar provision in the Civil Code, which predates the labor law. But there is a basis for it in current law. And that's really more or less what the new labor law says about these non-compete. So there hasn't been huge change. There's been a little bit of change.
Okay, but at least interested to see, because there have been a lot of talks around employers not always fulfilling their obligations during pre-COVID, but during COVID, it's really come to light with a lot of employers struggling. And so now knowing that if you do not fulfill your obligations, you cannot claim your rights afterwards as an employer is, like you said, I think fair. People are asking about termination during a fixed term contract. So what are your obligations?
As an employer, your obligation
As an employer.
is to give the notice. So whatever you've agreed with your employee, whether that's the 30 days up to the 90 days. And so you've got to give the notice, obviously pay the notice, give this time off for them to find another job. If they've accrued holiday that they haven't taken, then pay for that holiday on termination, and pay end of service gratuity. Now, the law still says that employees should have a valid reason for dismissal, but Article 49, I think it is, 49 or 47, it talks about arbitrary dismissal. Now, at the moment, we have this provision which says that an employee, basically, if an employee is terminated for a reason unconnected to their work, they can claim arbitrary dismissal, and then the maximum compensation for a successful claim is 3 months. But under the new law, we don't have those provisions. So we have a provision that says if an employee successfully complains either to the ministry or to the labor court, that and then the employer dismisses them, that will be an arbitrary dismissal. So in essence, if an employer victimizes somebody because they successfully complain about a breach by the employer or something the employer did, then the employer terminates, that will be an arbitrary dismissal, and there could be 3 months compensation. There's also a list where an employer can terminate for gross misconduct. So the same kind of principle as under Article 120. And there's also a longer list, which doesn't really exist in the current law, of where an employee can terminate and basically just leave, saying, I've been treated so badly, I have the right to leave now. But there isn't this general clause in the new law about arbitrary dismissal. So this new law is very employer friendly.
It'll be interesting to see how it comes into play. I know there are so many questions around termination. I'll just take one more, which is around redundancy. We've seen redundancy being a valid reason for termination during COVID. Is there any such provision under the new law?
So the new law, we have this clause that says that employment may be terminated for the following reasons, and it includes closure of the establishment, and also closure of basically the part where the employee is working. So yes, there is definitely a bit more recognition now for redundancy type scenarios, but there still isn't a complete recognition for the scenario where you've just had a bit of a downturn, and instead of needing 20 people, you've decided that you need 12. So you're going to have to get rid of 8. That still isn't recognized in the law. But again, going back to this point about how the new law does not appear to really have a clear-cut arbitrary dismissal clause, actually your reason for termination might be restructuring. You would terminate, give notice, and then then the employee can't really claim anything else other than the notice and their gratuity and holiday. Is the way the current law reads. Now, obviously, we have to wait and see. We have to see how the labor courts analyze it and apply it. But it seems to be that the scope now, from the 2nd of February, for individuals to claim compensation purely for the termination itself is much reduced.
All right. We have a few minutes to talk about what has been the talk of the town for the past few weeks and is confusing everybody, the new working week.
Yes.
So the new working week update, well, many knew that had been in talks for a long time, but the announcement has come as a surprise to many, not the least because of how short the notice is between December and January for government entities to make the change. Now, government, as far as we understand it, government entities and schools are affected by the changes. Can you tell us what the regulations are for them, and what do you foresee for the private sector, perhaps?
Yeah. So like you're saying, the work week has changed by law for the public sector, and the schools, both government and private, have said that they will change. So those are two very big pulling factors for employers in the private sector to change their work week. But it is a choice. So for the private sector, employers, there's no law saying that employers have to change their work week. And now, obviously, the more employees that you have who have children, then there'll be a big pull because they want to have the same weekend as their children. If their children are at home on Saturday and Sunday, they will no doubt, I assume, want to be at home with them as well. And so there'll be a bit that's a big pull. And then all government institutions are going to be working this Monday to Friday week. That means, the courts, the free zone authority, all the government departments and so on. Now, so what do you do as an employer? You can consider, you don't have to, but you can consider. And from the conversations we're having, most employers are looking to move their work week. Now, how quickly they do it is really a decision for them. And I think that's one thing that maybe hasn't been stressed enough. It really is up to you when you do it, how you do it, and if you do it. So the pressure, I think a lot of employers have been feeling a lot of pressure to do something quickly. Some employers, there've been a few poll tests of this, and one that I saw was saying that 43% are just going to wait to see of that particular survey. We're just going to wait to see what happens and how it works in practice. And the other kind of 57% were saying that they were going to move. So we kind of split a little bit 50-50. Now, the big thing, I guess, is for some for many organizations, there are people who are based in the UAE, but whose whole focus is, the Egyptian market, the Saudi market, Bahrain, and so on. And so putting all of that together, what I've seen from a lot of the organizations that we work with is the following kind of three models. One is moving to a Monday to Friday week. And when I say Monday to Friday, I mean a full 5-day week, not a half day. I have yet to speak to an employer who wants to move to a 4.5-day week. They're all sticking with 5 days. And so the three models, one Monday to Friday with an extended break on Friday for all employees. Now, I guess the main thinking behind that is to give Muslim employees who want to go and observe prayers the opportunity to do so, but also not wanting to discriminate. They're giving the break to everybody if they want to take it. So the primary motive is so that Muslim employees can have the time to go and pray. And then the 2 hours, so 1 hour is the normal break, 2 hours is the extra break. The additional hour is the extra breaks, and the additional hour has to be made up. Either the person starts their day earlier or ends their day later. The other model is Monday to Friday, with Friday being completely flexible. So, and this really just depends on the organization, whether it works and whether it's sort of its part of its culture for it to work. But, Friday could be worked at home, could be worked in the office, or a combination. And so people are just free to manage their school pickup, free to manage their, prayer time and so on. And the third model is for people who are based in the UAE but working on different markets. And for them, there are many employers who are just asking them to stay on the Sunday to Thursday week, because even though they're based in Dubai, if their whole focus is on Saudi or their whole focus is on Egypt, then they need to be working the same work week.
Okay, so to recap, because I've seen a lot of these questions prior to today's session, the Monday to Friday week is mandatory for schools and government entities. Private sector can choose if they do it at all, and if they do, when they may decide to make that change. And what we're seeing now is a lot of wait and see. Some sectors are moving faster than others, but again, it will depend on the countries with which you are. The 4.5-day week is only for government employees. The law, because I've seen this in the questions, the law does not mandate that the private sector adopts a 4.5-day week and keep paying employees the way they were doing before. So it's really up to employers. And the final thing which you mentioned is that employers then are obliged to give employees who need it 1 hour, one additional break hour on Friday in order to pray, but that hour will be made up during the employee's working week in order to keep the contract. Is that correct?
Yes, that's correct. Yeah, I mean, the Ministry of HR, I think because there's, all of these discussions are happening, and, they're aware of it and they're picking up on it. The Ministry of HR came out in the last 2 weeks. They've made a lot of statements. They're kind of putting a lot of, on Twitter and, social media and so on.
Yes.
They're making a lot of statements really emphasizing Muslim employees need to be given the break to go to Friday prayers. Now, the Friday prayer thing, it really depends where your office is located and where people work, because there might be a mosque next door that's going to do the Friday prayers. Now, one of the things is, not every mosque will do Friday prayers. They usually have to be at least 40 people for a mosque to do Friday prayers. So, it's not just as simple as kind of going down into the building and going to the prayer room. It's a little bit, more involved than that. So, which is why there's kind of this push and this direction from the Ministry of HR to say, there has to be a break for people to go and do their prayers if they want to do it. no,
Exactly, if they want to do it.
Exactly.
But I think again that's an interesting one, where similarly to what we spoke about earlier, with some of the new regulations making employees feel a little unsettled around the new contracts and things like this one may make some employees, whether they're Muslims or not, a little unsettled about having to work Fridays, and that would be a whole different discussion that we could have separately in a forthcoming webinar. But we have talked a lot about this type of situation during COVID, and employees not necessarily accepting measures that employees were taken. And at the end of the day, it was all about the duty of care, all about ensuring that you communicate rightly with your employees, that you leverage your line managers to pass on the message, that it's a culture change that you embark your people with, and so it doesn't feel like it's done to them, but with the business. And I think that's why we're seeing you're highlighting the importance of staggering change or taking your time, not just changing everything at once. Do you foresee in the future that the timings during Ramadan might change, or is that something that is covered yet? Because at the moment, employers must give shorter working hours. Is that correct? During
That's correct. So at the moment, well, and I think this is probably something that will change. At the moment, the way the current law is, everybody, regardless of religion, gets 2 hours less. And what the new law says is that the implementing regulations will specify Ramadan hours. And I'd predict that actually the implementing regulations are going to say it's only Muslim employees observing the fast who will get reduced hours. So I think we will see a little bit of a move there. But again, the Ramadan hours have been left for the implementing regulations. And we've, everyone who's been in the UAE for the past 10 years has noticed every year in Ramadan, we get a little bit more liberal. Shops are now open, restaurants are now open. There's not so much of these kind of black curtains and so on. So I think there will be a change. I think Muslim employees observing the fast will still get reduced hours, but probably they will be the only ones. I would predict that change will probably happen.
Yeah, and I think that a lot of employers were already doing that, and a lot of employees were respecting that. They would let the colleagues who are fasting benefit from the shorter hours. There was a question around working. So there is now a maximum number of hours that employees can work in a week, and a minimum days off that must be given. Is that correct? Was that there before? What are the changes around that?
Around the work week?
Yeah, work week in terms of, so working hours, has it changed from before, or is it just that it's been clarified? And we've now seen being highlighted in the newspapers, I think, that employees must have 1 day weekend at least. Is that for everybody? Is that covered in the law for all types of employees?
Yeah. So, I mean, it's always, so even the current law has this system of you can ask employees to work 6 days a week, but everybody is entitled to 1 day rest. Now, under the current law, the 1 day rest was always a Friday. But the new law, obviously, it's just any day. Any day that an employer and employee agree can be the weekly rest. And then in terms, in terms of overtime, 8 days, again, it's the same. It's been kept in the new law, 8 days of normal time, 2 hours of overtime on a kind of normal weekday. One of the good change is that the new law is very clear about the overtime and how it's calculated. So there's a lot of confusion in the current law about how to calculate overtime. But the new law is super clear. It says that it's only on basic salary, although the different rates apply. So it's 125% if it's on a normal work day, the 2 hours. If it's nighttime work, then it's 150%. If it's time on a weekend or a public holiday. But it's super clear that it's only on basic. So that's a really good amendment that it's clear now. The other change actually, and again, we have to wait for the implementing regulations because the law says that the implementing regulations will explain more about shift work, and they'll also explain about which sectors can operate different working hours, and they'll explain who's excluded from the working hours and these kind of restrictions on 8 hours and 48 hours and so on. So, that's a good thing. But one thing that is in the law, which I'll mention to kind of wrap this bit up, there is this provision that says you can have 8 hours a day and 2 hours of overtime. But then it says that an employee should not be working more than 144 hours averaged over a 3-week period. And when you do that, when you average 144 over 3 weeks, that means 8 hours. Now, why is that there? I think it's there so that it's to prevent what actually happens a lot of the time now, which is that some employers will just build into certain employees' shifts that they will every day be working 10 hours. You know, they'll do 8 hours normal time, they'll do 2 hours of overtime, and they will do that every day for 6 days, which is pretty tough. So I think this law is designed to prevent that happening every day, you know, of a normal week or a normal month. And now you might do 2 hours or 3 hours, or 1 week you might not do any overtime at all, so that on an average over 3 weeks you are just doing the normal 8-hour day. But again, we need to see what the implementing regulations say.
Yeah, and it would be interesting because, like you have said, a lot of these new updates are really supporting employers and giving a lot of flexibility to employers. Traditionally, whenever there were provisions that were supporting employees, I know I've been asking you a lot, we haven't always seen how it turned out in court, if employers were actually punished for having, for example, not having respected some of these laws. And there's customs that are on the side of what the law actually says. So it would be interesting to see how that evolves. I know it's already 5 p.m. So I will just take a couple of quick fire check questions, anybody who's put their last questions in the chat, and we will wrap up. A lot of questions again on end of service gratuity. So to confirm, employees who are terminated for gross misconduct or other reasons are still paid gratuity?
Under the new law, yes.
Under the new law, yes. Do we have a cap of 8 working hours a day? Not exactly, but you've said no more than 144 hours averaged over 3 weeks, and no more than 3 hours of overtime per day, is it?
Two hours.
Overtime per day. Okay. If someone would share a work model by working for 2 employers, so if an employee is working for 2 employers, which employer shall be the one paying his health insurance, and how can we avoid a situation of overlapping? So in the case of these new work models, do we know anything about visas as well and healthcare? Nothing yet?
Not at the moment, no. So again, that's been something that's been sort of kicked to their implementing regulations. I mean, at the moment, the Ministry of HR has a system for part-time work, and with that, the healthcare and the first employer is responsible for the healthcare and the main employee benefits, and then the second employer, it's sort of like a secondary job. And it's just agreed with the second employer on a contract basis. So hopefully the implementing regulations make it a little bit more even, so that it's a bit more balanced, and not only and not the first employer just paying for everything. But we'll have to see. Yeah.
Makes sense, but we have to see. And do you foresee delinking the sponsorship from the employer in the future, given the variety of options available?
Yeah, I think so. I think that hopefully that is definitely coming. It's coming a little bit by stealth, you know, especially in Dubai, the number of people who've been given golden visas. Now, I have to say, I think there will be, let us say, maybe like if you call it a 2-tier system, you know, it's still going to be different for what the ministry categorizes as a kind of unskilled. And they generally call them skill sets, sort of employee groups 1 and 2. Or is it 4 and 5? Anyway, the bottom ones. Sort of. So I think there will still, you know, those people will still require visas. It'll still be linked to the work and so on. But I think for other groups, we are starting to see it getting the two separating out. You know, golden visas, especially in Dubai, have been given, you know, quite honestly, to so many people. I had somebody say to me, "Oh, it doesn't feel that special anymore. So many people have them now."
Well, if someone gets one to hand off, we'll take it. No, it's true, and we've also seen a few changes for tourists who would come and work from here, remote work visas, etc. So great. Khaled is asking, could we think, so in regards to working hours, would it be thinkable to increase the daily work hours to 9 hours a day, since it's not prescribed what it should be per day, but what it should be on average? And for example, give half a day on Friday to employees. So effectively do a 4.5-day week, but almost like compressed hours.
Yeah, I've had a lot of questions about compressed hours, and I think at the moment the law isn't clear, so we need to wait to see what these implementing regulations say as to whether we could do that, because there is the law, the new law as it is, says 8 hours of normal time a day, and if people are going to do more than 8 hours, then it's technically overtime. But there is this reference to flexible work, which, flexible work, when we think about it from a people kind of HR perspective, that can be all kinds of things. That can be compressed hours, that can be job sharing, that can be all kinds of stuff. So we'll just have to see what the implementing regulations say about flexible work, and how we could apply it. It's a little bit unclear at the moment, because in the new law, flexible work is referred to as work that changes according, or the hours of work change according to the employer's economic needs, which kind of imply that it's a little bit seasonal. But compressed hours
It's a
is
little bit one-sided.
a little bit one-sided. Yes, I mean, compressed hours is the job is the job. You're just deciding to do it in 4 days. So I think with compressed hours, we'd have to be a little bit careful about doing
Great.
it.
I'm mindful of the time. Thank you so much, Sarah, for answering all our questions. And I tried to take as many as I could from everybody attending today. So thank you so much for dropping in the chat. I hope we covered as much as you hoped we would, and that you now have some more clarity over what's happening. I'm aware, when I was chatting with you, Sarah, earlier, of the frustration there can be with having a lack of clarity over certain things that you're supposed to be adapting to very soon. So with that said, we can't give information we do not have, but thank you so much for being so open. I know there are a lot of questions around technically amending contracts, and around how do we do it? Is there a cost for it? What kind of statement do we need to put in order for contracts to renew immediately? All of these questions, I believe, are questions to ask directly to Clyde Co under their services as an employment lawyer. Sara Khoja is a partner, and their team is incredible, and they have offices all around the region, cover all the laws. Which brings me to January 18. We are having a 1-hour webinar at 1 p.m. Saudi time, so 12 p.m. UAE time, on the new updates to the Saudi Labour Law and how they will affect employers in the region. We will continue to have a program of monthly webinars in the new year, like we have started this year. Some of them will be informational sessions like this one, other are more open discussions and panel discussions. I know there will be a lot of discussions around 4-day weeks, around flexible working, competition and rewards, so please do stay tuned. And if you've enjoyed this session and would like to know more, not just about the updates, but about everything else and the broader context of the UAE Labour Law, we are the exclusive partner of Clyde Co for training. So there is CIPD training, which covers UAE Labour Law, which is a 2-day course delivered virtually. And there's also one for Saudi, and they are both available in Arabic for your teams. You will be receiving a recording of this session in your inbox if you've registered, together with the links to the course. And please let us know if there is anything you'd like us to talk about. And lastly, I promise I'm done after this. We would love for you to answer a short survey, which will be sent to you in the thank you email. Everybody wants to know what everybody is doing with regard to that new working week, with regards to the new provisions, with regards to flexible working and hybrid and returning to work. So if you would take just a couple minutes of your time and let us know what you're planning to do, it will help the whole community. Thank you, everybody. Thank you so much, Sara, for joining me.
Thank you.
Have a lovely end of year and Christmas if you are celebrating.
Thank you.